Good afternoon, everyone. Welcome to the CITP seminar featuring Anita Allen, who's going to talk about her project, How Privacy Got Its Race. This webinar is co-sponsored by the Center for Digital Humanities at Princeton, and the Center for Information Technology Policy is excited to bring it to you. My name is Ari Waldman. I'm a professor of law and computer science at Northeastern University. And it is my pleasure to introduce Professor Anita Allen, who's going to be the leader, who's going to give a talk about her research, about her project, and then we'll take questions after. Anita Allen is an internationally renowned expert on privacy law and ethics, and is recognized for contributions to legal philosophy, women's rights, and diversity in higher education. This past July, Anita stepped down as the University of Pennsylvania's Vice Provost for Faculty after 7 years in that position. And in 2015, she was the chair of Penn's Provost Advisory Council on Arts, Culture, and the Humanities. From 2010 to 2017, she served on President Obama's Presidential Commission for the Study of Bioethical Issues. She was presented the Lifetime Achievement Award by the Electronic Privacy Information Center, or EPIC, in 2015, and elected to the National Academy of Medicine in 2016. In 2017, Anita was elected Vice President and President-elect of the Eastern Division of the American Philosophical Association. And in 2015, she was on the summer faculty of the School of Criticism and Theory at Cornell. A 2-year term as an associate of the Johns Hopkins Humanities Center concluded in 2018. And in 2019, Anita was elected to the American Academy of Arts and Sciences and received an honorary doctoral degree from Tilburg University. She received her law degree from Harvard and her Ph.D. in Michigan from philosophy. Anita's books are canonical in the privacy space. Those of us who work in this space cite her often and rely on her work which has been foundational in the field. Her books include Unpopular Privacy, What Must We Hide, which was published in 2011, Privacy Law and Society in 2017, The New Ethics, A Guided Tour of the 21st Century Moral Landscape, and Why Privacy Isn't Everything, Feminist Reflections on Personal Accountability. So the way this is going to work is Anita is going to give a talk, and then we're going to take questions from the audience afterward. So if you're interested in asking a question, please don't hesitate to type it out in the chat, and then I'll ask Anita those questions, and then we'll engage in a discussion toward the end. So with that, I am super proud and honored to hand this over to Professor Anita Allen. Thank you so much for being here, Anita.
Thank you. Thank you so much, Ari. This talk was supposed to have happened in the spring of this year, and the coronavirus pandemic made it impossible for that to take place. But had it happened in the spring, the topic of my talk would have been completely different. Like a lot of people, I've been deeply affected by and in many ways transformed by the events of the last 6 or 7 months, both the ever-presence of the pandemic and the political uprisings and civil unrest around race following the murder of George Floyd, and then the very divisive political election that we've just gone through and are still, in fact, going through. So this talk reflects my growth as an intellectual, as a scholar, as a person, reflected by the events of recent months. So it's raw, a little raw, because some of this material is not digested. I've not presented on this topic very many times before. In fact, this is only the second time. I had been invited in August to speak in September to the International Association of Privacy Professionals on the topic of the intersection of race and privacy. And that invitation got me thinking about the intersection of race and privacy differently and better. And I got so excited by the topic, I decided to build a whole course around it for the spring semester 2021. And so I'm emerging as someone who incorporates perspectives on the intersection of race and privacy overtly in her work. So today, stressing the political and ethical values that inform the law. I want to explore how the interests and contributions of African Americans and to some extent other minority groups have shaped privacy law, privacy policy, and theory. I want to talk about how privacy laws, along with the business and governmental policies and practices, can advance, target, and exclude minority group interests, which is a bad thing, and how policy impacting technologies, including cameras, drones, algorithms, encryption, facial recognition, and smartphones can be used as mechanisms of social control. I want to do all these things. Obviously, I can't do all of them today. My academic career as a privacy scholar has spanned 35 years, and I regret, I must confess, not having done more of these things already. But the intersection of race and privacy and data protection is beginning to get the attention it deserves, and not just from me. I'm the least of all. It's the focus, for example, of a new book that came out from Cambridge University Press very recently. It actually has a 2021 publication date, but it's available now, and it's called Privacy at the Margins, and it's by a scholar named Scott Skinner Thompson. So, quoting its author, this book, quote, documents and highlights many of the ways in which the privacy of marginalized communities across several intersectional demographic groups is uniquely endangered by both government and privatized surveillance regimes, broadly defined. The dramatic concrete harms caused by that surveillance, and correspondingly, why privacy for such communities is of heightened practical and material importance. He continues, those who are already in the most precarious social positions are disproportionately vulnerable to privacy violations, while the privacy of the privileged is more protected, and this is no accident. I think that Skinner Thompson, whom I don't know and have never met actually, rightly advocates centering what he calls privacy's expressive and anti-subordination dimensions in discussions of why we need privacy rights. And just to say that again, sort of centering the expressive and anti-subordination dimensions of privacy discussions in privacy discussions of why we need privacy rights. And to some extent, I've done that before. I talk a lot about gender in my work, to some extent about LGBT as well. But I'd like this idea of really, truly centering it in discussions of privacy law and privacy rights. So in the book, Skinner actually cites an article that I published way back in the early 1990s called How Privacy Got Its Gender. The article was about the respects in which 19th century class-based gender norms played a role in shaping and justifying the need for the right to privacy in common law. And if you closely analyze the famous 1890 Harvard Law Review Warren and Brandeis article, as I do in my paper, How Privacy Got Its Gender, you can make a pretty good case that the right to privacy was born and conceived to protect the values and privileges of more affluent classes of heterosexual men, with rhetorical force drawn from the concerns that were prevalent at the time about women's modesty and seclusion, their virtue, and their domesticity. So protecting the woman's domain, the home, modesty, were salient goals and purposes of early privacy law, in fact. Because because of privacy interest, for example, just sort of thinking about some of the cases at the time, case law, a decent woman should not have an unmarried, unprofessional young man in her home while she's giving birth to a child. A decent woman's image should not be used in commercial advertisements. A statute honoring a woman, a civic-minded woman even, should not be placed on public display without the permission of a woman or her husband and families. A woman should not be required to undergo a physical examination, even though she's the plaintiff in a tort action alleging physical injury. But looking back on 3 decades, I now in the era of George Floyd, right? I wonder why it didn't occur to me way back after I wrote How Privacy Got Its Gender to write a paper called How Privacy Got Its Race. because privacy does have a race, just as in a sense, privacy has a gender. The article that I did not write would have emphasized the deafening silence in early privacy case law and scholarship respecting the privacy interests and needs of America's racialized minority groups, African Americans, Asian Americans, Native Americans, Hispanic, Latino Americans. The right that Louis Brandeis called the highest of civilized man, seemed to not be pertinent to the problems of people that are shaded black, brown, yellow, and red. But I suggest that the gender of privacy articulated by Warren and Brandeis was female, but the race of that privacy was definitely white. A small body of scholarship explores the implicit race of privacy with the origin story of American privacy law in mind. In a striking paper that I've been lucky to discover recently, a paper called The Whiteness of Privacy, Race, Media Law, Eden Osuka compares the public reaction to Aunt Jemima's image on flower packaging to the public outrage in New York about the outcome of Roberson versus Rochester Folding Box Company, in which a young white woman unsuccessfully claimed that her portrait had been appropriated for use on flower packaging in violation of her privacy. So she lost her case, but she won the battle because a statute was shortly passed thereafter in New York that created the right to privacy as a matter of statutory law in New York State. But Osuka draws on histories of photography and consumerism, legal history, cultural history, and a visual archive of Aunt Jemima's trademark to argue that anxieties about media disclosure and commodification of white women that saturated the legal text and media privacy were correlative to the spectacular forms of expression, I'm quoting her, and commodification of Black subjects that was routine in the era's commercial print culture. So, a Black woman's face can be on a box of flour. Nobody finds that objectionable. If a white woman's picture is on a box of flour in 1904, we start to panic. Oh my God, somebody might see her picture in a magazine or in a bra even, or in a brothel even, and this would be a tremendous violation, bring shame upon her, and create the implication that she's a model, somebody who is willing to commercialize and commodify her own body, which is a bad thing for decent women. So again, Roberson lost her case in New York court, but she won because a law was passed to protect people like her from commercial appropriation. Importantly, though, the seeds of a class and gender critique of the notions of privacy were found in the era of Warren and Brandeis, well before the 20th century. For example, E.L. Godkin, who was a contemporary of Warren and Brandeis, wrote a couple of articles, actually the same year that they published their famous 1890 article, Right to Privacy. He published a couple of articles arguing that the law cannot confer privacy as a positive right, and that people need homes and rooms of their own in order to have meaningful privacy, something that the law cannot provide people, cannot give them. And then a few years later, the utopian feminist Charlotte Perkins Gilman, she observed that the so-called private home is the last place on earth that a woman can enjoy individual forms of privacy due to the constant demands of caregiving and caretaking imposed upon women, and the constant stream of workmen and tradespeople coming in and out of the family home. So already by 1906, when the first state Supreme Court recognized the right to privacy, there could be no overlooking the fact that privacy is a commodity secured by wealth and privilege, secured by gender, combined with wealth, so that class and gender make a big difference in one's ability to find and enjoy individual forms of privacy and private choice. A recent paper goes pretty deep into the origin story of the right to privacy. This is a paper by Matt Reichel from 2017, an essay called Race, Class, and Privacy, a Historical review. And in this paper, he, quote, inspects the maldistribution of privacy rights across race and class divisions by engaging in social history of the development of these rights from their inception in American jurisprudence. In doing so, his essay, he says, shows how privacy and property rights have an intertwined history through which an antagonism develops in capitalist societies' attempt to balance property rights, social equity, and public trust. So a flourishing white male artist in Atlanta, Georgia, was the successful plaintiff in America's first privacy tort case, the first case to find that there is a legal right to privacy of any sort, but it happened first before it happened in constitutional law. It happened in tort law. The case was called Passage versus New England Life Insurance Company. And it's ironic, highly ironic, that Georgia Supreme Court Judge Andrew Jackson Cobb, a man from an elite slave-owning family, Confederate family of Confederate loyalists, this judge compared a person whose privacy has been invaded through commercial appropriation of a photograph to a slave with a merciless master. In this case, the court held that a man whose photograph was used without his consent in an advertisement for life insurance had a valid cause of action for invasion of privacy in common law. The court used a combination of positivistic law arguments with striking natural law contactarian arguments to justify finding that the right of privacy existed in the common law. After making his natural law and positive law arguments, Judge Cobb elaborated on the sort of injury to which an invasion of privacy amounts. And if you're interested in this, I've actually written a whole paper about this for the Fordham Law Review, a lecture on natural law and their natural law series in 2012. And I just go into great detail, almost like a line-by-line analysis of this opinion. So it's there if you're interested. But just briefly, Judge Cobb stated that invasions of privacy amount to slavery, the coercive institution that had been recently abolished in his home state. I'm going to quote him because it's so important to see how today, at a time when we struggle, say after a data breach, to articulate what's the harm done, this judge, more than 100 years ago, saw privacy harms as incredibly serious problems and wrongs. He says that the knowledge that one's features and form are being used for such a purpose and displayed in such places as advertisements are often liable to be found, brings not only the person of an extremely sensitive nature, but even the individual of an ordinary sensibility to the realization that his liberty has been taken away from him. And as long as the advertiser uses him for these purposes, he cannot be otherwise than conscious of the fact that he is, for the time being, under the control of another, that he is no longer free, that he is in reality a slave without hope of freedom, held to the service by a merciless master. God, I bossed that beautiful line. I'm going to read that again. He cannot be otherwise than conscious of the fact that he is, for the time being, under the control of another, that he is no longer free, and that he is in reality a slave without hope of freedom, held to service by a merciless master. There you go. The equation of privacy invasion to slavery is more than casual rhetoric here. I mean, the first time I read this, I just, throwaway line. But this is an analogy which was not to have been expected, because the judge who wrote it, he had been taken care of by slaves as a child. His father owned slaves, his grandfather owned slaves, his uncle owned slaves, his uncle wrote the Constitution of the Confederacy. This is a man who knew firsthand what slavery amounted to. It's not a throwaway line at all. And the analogy would not have been expected. Think about it. In the notorious case of State versus Mann, the concept of privacy was used not on behalf of the enslaved person seeking justice, but on behalf of the master seeking non-interference with his personal rights. The idea of privacy was employed in that case, that 19th century case, to help rationalize the court's unwillingness to punish a white man for whipping and shooting an enslaved worker. The power of the master, the court said, must be absolute to render the submission of the slave perfect. Bloody vengeance is heaped upon defiant slaves with impunity by reason of its privacy. So Cobb's slavery analogy could be understood as hyperbole and literary flourish out of context, but not in context. This was Georgia. This was Georgia just a few decades after the end of the Civil War. And what I find, and what I've argued in my work, is that the way Judge Cobb talks about privacy is very much in line with the human rights and fundamental rights discourses of privacy found in the EU. And it has less affinity for the thin notions of value and the value of privacy found more often in the sort of choice and consent type discussions about the value of privacy that we have after the internet in the United States today. So Privacy at the Margins author, Skinner Thompson, is correct that privacy rights can potentially serve important anti-subordination goals. And because I come to Skinner Thompson's work from the point of view of a native of Atlanta, entranced by this Georgia Supreme Court case in which the judge analogizes invasions of privacy to slavery, and I buy the notion that invasions of privacy are to varying degrees intrusions and deprivations of freedom that are extremely important. The larger the privacy invasion, the closer we become to like slaves. So I think this is a great framework, and I intend to use this framework, the anti-subordination slavery analogy framework, more often moving forward to help me think more carefully about the intersection of race and privacy. A couple of things about what happened in privacy law that might relate to my topic sort of after the early 20th century, more into the late 20th century and into the 21st century. Very briefly though. Well, the sexual revolution, came with its critique of domestic privacy, as did the gay rights movement. By the 1980s, it was very well appreciated that privacy for women meant decisional privacy, including decisions about pregnancy and childbirth, not just seclusion in private homes. And gay people needed decisional privacy to freely choose their sex partners, keep police out of their bedrooms, and be permitted to enjoy intimacy, not only in sketchy havens like restrooms and bathhouses and parks, but in their own homes, openly and freely in society. In fact, about 10 years ago, I wrote a paper looking at how useful the privacy tort had been to that point for LGBT plaintiffs. And I found that what are deemed privacy invasions were too often not indeed deemed highly offensive to a reasonable person if the plaintiff was an LGBT person. That the courts often found that it's reasonable to intrude upon the privacy of gay people, including peering in their bedroom windows and taking pictures of them to use in the child custody court if they're gay. So in any event, so there's that history, but let me just focus on Black people now, because I really do think that where my work is going to be most impactful, because it's most informed by my own experience, is the intersection of race and privacy as it affects and as it reflected by the experiences of African Americans. But you could think about this topic in relation to everything from California Japanese Americans being ripped from their homes and placed in camps during World War II. That's a pretty big privacy invasion. Or the surveillance of Puerto Rican nationalists in New York several decades later. But I am going to focus on African Americans, if you'll indulge me that today. So race was not an important part of privacy jurisprudence in a big way until the 50s, 60s, and 70s, when encouragingly high court regard for privacy and private choices of Black people can be observed. So here's some positive history. So NAACP versus Alabama, right? Black plaintiffs bring a lawsuit to prevent the state of Alabama from getting their membership list. And our Supreme Court finds that there's this thing called associational privacy that protects Black people from disclosures that would expose them to harm. Loving versus Virginia, right? Black woman with a white husband brings a case that goes all the way to our U.S. Supreme Court. Supreme Court finds that interracial couples have a right to marry, and that the marital privacy is part of the discourse in this right, and Black people help to establish, right, therefore, that there is a right to associational privacy and to marital privacy. And then, although the plaintiffs in Roe versus Wade and Griswold versus Connecticut were by no means African American, the argument that African American and other less privileged women needed to have the same access to birth control and abortion that rich women already had, despite the law, was one of the motivating factors that led activists to pursue the right to privacy in the abortion and birth control context. So Blacks were not merely on the receiving end of privacy law. Blacks helped to make privacy law. And this is a very important perspective to bring to this discussion, that Blacks have helped to make privacy law. And they've made it through being petitioners and plaintiffs. They've made it through being also judges. So, Justice Thurgood Marshall, the Supreme Court's first African-American judge, wrote the majority opinion in the Supreme Court case Stanley decision that established intellectual privacy as a right grounded in the First and 14th Amendments. Right. So Blacks ignored in the early history of privacy law, but you see these wonderful ways in which in the 1960s and 50s, 60s, and 70s, Black people's interest and their talent is being brought to bear on the law to advance privacy law. Okay, here we are now in the digital age. The events of the last several months have underscored that U.S. political culture is complicated, divisive, and distrustful. Many minority group Americans feel like the larger society continues to let them down by turning a blind eye to police violence and health disparities. I've been asked during this period for the first time in my life to comment on race and privacy by various organizations. I've also been asked a lot to comment on the privacy implications of the coronavirus pandemic, and I have a lot to say about accountability and privacy in relationship to public health, but that's a different topic. I do think that as a parent and an optimist, I prematurely, like a lot of people, declared civil rights a victory and left my children unprepared for the world in which the White House is insensitive to the demands of true equality, and in which George Floyd could be murdered in broad daylight, surrounded by a Greek chorus pleading for his life and compassion, in which a young jogger can be gunned down, run off the road by vigilantes just because they don't like having a Black person in their neighborhood. The surveillance society created by the digital age is one that few parents of any race have had the resources needed to educate their families. And I'm struck by the fact that many Blacks and their allies writing about surveillance society do not talk about privacy at all. So, I'm here today in a way arguing that we should all be more concerned about the privacy of African Americans. But I've read in the last couple of weeks a number of books written by recent books from publication dates of 2020, 2019, recent books in which there's a discussion of digital culture, cyber culture, software culture, etc., in which the term privacy is not even indexed in the book. So I'm reading books like automating inequality and Black software and bearing witness while Black and distributed Blackness and race after technology and dark matters and algorithms of oppression, and many of these books are written by Black people, and few of these books have any significant discussion of privacy. It's sort of as if Black people think that privacy is a value that is not the main point, that there's a conversation to be had about the negative impact of digital technologies on Black people's lives. But it's not a conversation about privacy. It's a conversation to be had about the impact of the positive opportunities created by digital technologies, but it's not a conversation about privacy. I think that we should, as African Americans, focus on the privacy issue. And I think that there's work to be done by a lot of folks who spend a lot of time thinking about privacy already to think about it in relationship to some of the topics that these Black authors are thinking about, but who don't see privacy as the main point. So let me just name, some group of the digital age problems that we have to ponder. And some of them I've thought a lot about, before the last 6 months. And some of them I've thought about only for the first time in the last couple of months. So one that I thought about a lot long before the last few months, it's now kind of reemerging, is this topic of whether we should treat race as a sensitive private category. So as you know, in the EU, under the GDPR, like under the Data Protection Directive that came before it, race, along with things like religion and trade union membership and health information and financial information, is treated as a sensitive area, sensitive topic. But I don't think that race should be treated as private in the United States. This is an opinion of mine. There was an unsuccessful attempt in the early 2000s in California to ban the collection of race information. This was the Racial Privacy Initiative, so-called Racial Privacy Initiative. It was led by a Black man, Ward Connolly, who also opposed affirmative action and had more success getting affirmative action banned in California than he had getting race data as such banned in California. That the Racial Privacy Initiative failed. And it seemed to me at the time that racial privacy was a novel concept that would not help racial minorities in need of visibility, who need a certain amount of visibility and inclusion. And Patricia Williams, the law professor and scholar who you may know because she writes frequently for the Nation and is something of a public intellectual, Patricia Williams wrote an article, an op-ed about this initiative at the time. And she also, like me, argued that we don't need to treat race as a private matter in the United States. So right now, as the United States is creeping toward, and I say creeping advisedly, creeping towards new privacy legislation modeled after developments in the EU and California, we have to be concerned about whether anti-progressive mischief could be accomplished by legislating that race be treated as private, further undermining targeted remedial welfare and education programs. Another topic, tech and privacy are commodities and privileges of class, gender, and race. So wealth includes the ability to purchase privacy, the privacy of single-family homes on large lots, education and access to knowledge about how to protect privacy, privacy tools like Apple computers and encryption. So we have a problem that some technology that would be highly useful for work and education is not affordable by poor minorities, and technology that is may lack superior built-in privacy and security controls. So as Chris Sagogian has pointed out, now quoting him, the phone used by the rich is encrypted by default. This is the Apple phone. It's encrypted by default and cannot be surveilled. The phone used by most people in the global South and the poor and the disadvantaged can be surveilled. The gulf is the function of the fact that that iPhones come encrypted, whereas the vast majority of people use Android phones, and 95% of Android phones, actually 98% of Android phones are not encrypted by default, but 95% of iPhones are. So people are kind of falling into the necessity to use cheaper technology that happens to have a less good privacy protection. Now, this is really interesting to me. Some Black commentators on technology really hate when people start talking about how disadvantaged the minority communities are, how Black people don't have technology, they don't know how to use technology, they're not sophisticated users of technology, they're so vulnerable, blah, blah, blah. Some Black writers like to stress a different narrative under which Black people are aggressive users of technology. They may not have iPhones, but they are aggressive users of technology to their benefit. They've engaged in political organization, kept families together and strong, created senses of community through technology. Black Twitter, the majority minority web portals and pages that appeared on the internet. Um, um, these are important features of the relationship between Black people and technology that are often ignored, not only by white writers, but also by Black writers like myself. So I'm now moving forward in a more cautious way, rather than emphasizing the disadvantages that are suffered by the fact that we have technology. Let's, in our conversation, be aware that there's a powerful set of goods that have emerged from the access to technology by African Americans. In my family, I know many people have abandoned Facebook. People say, "Why are you still on Facebook?" It's the only way to reach my 18 first cousins and my great aunts and my 95-year-old mother-in-law. They use Facebook, so we use Facebook. Okay, another issue that getting access to state services requires giving up privacy. That there's a persistent concern tied to Blacks and privacy about their intimate and allegedly confidential relationship to the state. As lower income Black people, lower income Americans, Black people are often dependent upon government benefits like welfare stipends, Medicaid, food stamps, public housing, and public transportation. And to access these benefits, Blacks are required to make the state privy to personal information, and they have to agree to various forms of surveillance. Back in the 1980s, we used to worry about having CCTV cameras in the stairwells of public housing, and having welfare workers entering homes to check for unreported boyfriends and fathers. Today, the welfare state is more subtle. They also collect data through digital technologies and AI. Kiara Bridges wrote about this in her book, The Poverty of Privacy Rights. And she talked about how pregnant women, for example, when they apply for Medicaid, have to give tons and tons of information about their missed appointments and prenatal care or lack of it, whether the conditions, how they got pregnant, by whom, whether they've been abused, whether they use drugs. And some of this information gets funneled to the state, to the government, to immigration officials, et cetera. So, and the criminal justice system, et cetera. So this is a serious problem. I remember when I was a little girl, I didn't live in the city of Atlanta most of my life, but when I was a little girl, I lived there for a tiny bit of time, maybe about 9 months. And during that time, I would visit my cousins, and some of them lived in public housing. And I remember being told by my parents how, when you live in the projects, people can come to your house and check to see whether you have curtains and whether you're clean and whether you have food in your refrigerator. And I remember this struck me as very, very odd. And now I understand that this is a privacy problem that was a part of the lives of Black people, a problem for Black people way before the internet. It continues into the world of the internet and data collection. I'm reminded here also of the fact that when you have that we had the ID card issue in India recently, the Aadhaar card system, whereby all 1.3 billion people in India were expected to get this state ID card that was created by taking an iris scan, a fingerprint, and demographic information, putting it digitizing it, putting it on a card. And this card was required to access state services. But there was a feeling that people shouldn't be forced to give up the privacy of their body and information in order to get this card, and there would be abuses and there'd be hacking and so forth. So a case of objecting to this card went to the Indian Supreme Court, which ended up holding, citing the work of me and Helen Nissenbaum and many other women philosophers and lawyers, but citing our work to uphold the idea that there is a right to privacy in the Indian Constitution based on the idea of dignity. We need to bring that kind of thinking back to the United States so that when we think about what's wrong with some of the expectations about that people have to give up privacy in order to get state benefits, that we remember that there's a fundamental interest in dignity and non-subordination that's at stake here. Just a couple of more points before we open up for Q&A. Obviously, racial profiling is a huge issue. If Blacks are deemed inherently criminal and suspicious, facially neutral stop and identify regimes may disproportionately impact Blacks. I recently decided to go back and start checking on the race of the petitioners in some of the famous Fourth Amendment search and seizure cases. And I discovered that the petitioner in Mapp versus Ohio was a Black woman, and the petitioner in the famous Terry Stop case was an African American man. I want to look harder at this because I think there's a very interesting story to be told here about how the surveillance and control of African Americans has shaped Fourth Amendment law tremendously. Next point, new concept for me, weaponization of technology. Writers speak about the weaponization of technology to mean the use of digital technologies to suppress, control, and punish minorities. This is a problem in the United States. It's also a problem in China and elsewhere. You've all probably been reading those stories in the New York Times about the Uyghurs, the Muslim minorities in China who are being required to undergo incredible surveillance. There's cameras in every shop, in every mosque. There's cameras on the street. People have to have certain technology, tracking technology on their cell phones to enable the authorities to keep track of them. It's a tremendous intrusion and a tremendous diminution of privacy. Well, we know that technology can be in this way used against the minorities to promote majority interest in social control. AI, big data, the whole issue of algorithmic fairness. This is it's not in its purest form a privacy issue, but we've now come to understand there's a relationship between algorithmic fairness and discrimination and privacy, because some of the ways in which we get data into systems that's available to algorithmic analytics is through collecting data that does implicate concerns about privacy. And there are concerns that these algorithms may be error prone, that there may be hidden biases that disproportionately impact Black and brown people. And so this is what people worry about, the weaponization of big data through which governments can even more readily identify, control, and oppress. And I just want to point out that during the Barack Obama administration, a couple of major reports came out advocating the aggressive use of AI and algorithms and big data to improve the efficiency and effectiveness of government. At the same time, reports came out from the government, same people, cautioning about the discrimination and harm that can come from unfettered and insensitive uses of big data and algorithms. There was recently an article in the prominent science magazine journal Nature about that had this headline tells it all, right? Millions affected by racial bias in healthcare algorithm. According to this article, an algorithm that's widely used by U.S. hospitals to allocate healthcare to patients has been systematically discriminating against Black people. And this is something which you can also read about. I encourage you to. That is very disturbing. Next topic: prison. The use of supermax, the incarceration, the mass incarceration, we say, of Black people means that a lot of Black people have too much of the wrong kinds of privacy. And we have to address that issue moving forward more carefully. Facial recognition, probably the most discussed issue around minorities and Black minorities today and technology. Here, the concern is that there are a lot of false negatives, that the technology is not that great at identifying Black people. I'm constantly confused on Facebook using their facial recognition, whatever the algorithm, it constantly confuses me with other people that aren't me. My brother used to work for Microsoft, and he made these great conversations a long time ago about their struggles trying to make the technology better at reading Black faces. Facial recognition is a two-edged sword. On the one hand, lots of jurisdictions like California, even more aggressively, Oregon, are outlawing or thinking about outlawing. Oregon's outlawed public use of Portland, Oregon, public use of facial recognition technology. But it's a double-edged sword, and some African American commentators are saying, "Wait a minute, we want to be able to use facial recognition so we can identify the police, so that you have this sort of they're using it, we're using it, a balance of can be achieved." But I'm skeptical of that argument because I remember that when cameras, body cams first came out, a lot of folks thought that, well, body cams and cameras will, and police cars will mean that the police will be nicer to Black people. But then we see George Floyd, right? So does the ability to see what the police are doing or to see what Black people are doing make Black people safer or less subject to harm? Let's see. Just one more theme or topic, and we'll go to Q&A real fast here. Social media. So there's an argument here that that African Americans are losers because in terms of social media, because social media has created a flight from privacy. People want to be more visible. They want to be social influencers. But the low status of Black people means that it's harder for Black people to exploit the opportunities that are available in social media. So I will stop there. As you can see, there's a rich array of topics to be discussed. There's a rich history to be explored and retold from the point of view of African Americans and anti-subordination values. I look forward to some new projects and to more conversations and to more scholarly exploration of some of these areas. So I thank you and I welcome your feedback. Ari?
Thank you, Anita, so much. That talk just shows how broad and how your mind works there. One of the great things about your scholarship, not just this forthcoming scholarship, but things that you've done before has been bring together so many different issues into kind of coherent themes. That was one of the things that I got out of so many of your books and so many of your writing. So I encourage everyone everyone in participating to use the Q&A feature. It's in the newest version of Zoom. It's at on the bottom ribbon. You can just click on Q&A and ask a question. But I'll start to get the ball rolling. So when I teach information privacy, I always have, in addition to a class on surveillance and race, I try to integrate stories and information about how different marginalized populations are affected by surveillance. So we talk about things like, who are these plaintiffs? These plaintiffs tend to be women, or these plaintiffs tend to be queer, and queer people's privacy cases are about sex, and African Americans or Black people have privacy cases in different areas. So, but one of the things that I think is very interesting, I'd like to get your feedback on this, is that the scholar John Fisk wrote in an article this is back, I think, in 1998 in Theory, Culture, and Society about non-racist racism. And what he meant by non-racist racism was, here I'm quoting here, he says, a form of racism that has been developed by white-powered nations that avow themselves to be non-racist, but it's recoded, but their racism is coded into apparently race-neutral discourses such as law, economics, the IQ and education, health, housing, capital accumulation. Each of these social domains in which discourses that operate have racially differentiated effects, meaning that it's a very fancy way of saying that people can be overtly, oh, I'm not racist, but the systems in which they operate and the tools that they perpetuate, the tools that they work in perpetuate systemic racism. So, and this is sort of what you're talking about here with surveillance and totalitarianism and so forth. So the first question is, well, what do we do about that? You know, if we're steeped in non-racist, racist institutions, right, then either we have to tear all those down and start again, which is we need to work on that, but we also need to work from the inside. So what do we do about institutions or about people who feel that they're not racist, but are still perpetuating systems like surveillance systems that are perpetuating systemic racism?
Yeah, great question. So so you're right in thinking that part of my interest is in these sort of structural underpinnings, systemic racism, not just the personal subjective racism. And I don't think you have to tear down the system of government in order to address some of these problems. So, for example, if a racially insensitive group of people want to promote a racial privacy statute for California or for the nation, um, we don't have to tear down the system in order to fight it, but we do have to articulate the ways in which, while it might seem on the surface that it's very race protective of all races to not allow the government to have a collection of information, a data bank about that includes who our racists are, because of things like what happened in Germany in World War II. That this is not Germany in World War II, and that we have to articulate the reasons why some of the things that we're looking for, that we want to achieve, would be better achieved and justly achieved if we continue to use racial classification, racial categories, and don't treat them as highly sensitive. So it's as always, it's about political persuasion and education to get people to think differently about some of the things that they advocate. Anecdote. So I'm in a book club, and there are these wonderful, bright women. We're talking about why are white women afraid of Black men? You know? And so this woman says, I love her, but she says, well, Anita, I must tell you, I was mugged twice by a Black man in Center City, Philadelphia. And I thought to myself, very interesting. Even though I've been harmed several times by white men, I'm not afraid of white men because of that, right? So what is it about our relationship with African American men that creates a generalized fear that may be tied to nothing ever happened to us that involves being harmed by a Black man, or one thing happens because one or two Black people did something. So you generalize to the entire group, and so you feel it's justified. So then you support regimes of surveillance in urban communities because you've been mugged once by a Black man.
Right.
We have to break down those kinds of patterns of thinking, the fallacy of overgeneralization, as philosophers would say. Those are some of the ways. So we don't have to rethink. But I must tell you, Ari, and I'll tell everybody on the call, that after Tuesday of 2 weeks ago, the election, I started thinking, oh my God, I might need to give up on liberal democracy. Is it that I need to rediscover my Marxist underpinnings, because this isn't working. It's not working.
Well, that's a whole different topic. We should get back together to discuss that. I'm gonna paraphrase a question that's in the Q&A about the privacy rights of the incarcerated. So I appreciate the question. I'm gonna change it a little bit. So this idea that prisoners forfeit at least some of their privacy rights, or the incarcerated forfeit at least some of their privacy rights, has been used to justify a lot of mistreatment of the incarcerated. Things like body cavity searches, isolation, rummaging through their letters, and so forth. So can you speak? So the question asks you to speak more about the privacy rights of the incarcerated. I'll make it more specific. What is an avenue for making progress in protecting the privacy rights of prisoners if we exist in this world where people just generally accept that if you're incarcerated, you give up privacy rights? What is a foundation, or what is a basis for us saying that, no, that's not the case? Like, just because you're incarcerated, you don't give up privacy rights because X.
Yeah. No, I thought it was very important in my privacy law and society textbook, which is like, over 1,000 pages, but to have a chapter not just on the obvious privacy, constitutional privacy realms, the Fourth Amendment, the Fifth Amendment, the 14th, the First, on the Eighth Amendment. The Eighth Amendment, which says, that we can't impose cruel and unusual punishments on people. Because I think that a lot of what goes on inside of America's jails and prisons should be considered cruel and unusual punishment. If not unusual, because it's typical, it's nonetheless cruel. And a few courts have held that that there are some limitations on what jailers can do in the name of of control inside of prisons. But the general legal position is that you lose your privacy right at the prison door. So how do you get around that? And here's where the anti-subordination and the slavery analogy, I think, are helpful to me, because we don't say that when you commit a crime and are sent to prison, you are enslaved, that you are a slave, right? We don't say that. To me, that means that you cannot be summarily deprived of all the dimensions of human dignity and every single kind of freedom that a person can have consistent with your confinement. So that I think the emphasis should be on minimizing the privacy that needs to be taken away, minimizing the freedom that needs to be taken away, consistent with the legitimate aims of incarceration. Mm-hmm. The idea of using body cavity searches to humiliate people, right, needs to stop. Mm-hmm. The idea of random cell searches that are aimed at intimidation need to stop. The idea that people's letters and phone calls are monitored. I mean, there's good reason to do that. I'm not saying you shouldn't do that, but I think we should think about specifically about why we're doing it, and to not see the fact that the person is in prison as a per se justification for every form of surveillance and monitoring that goes on in prisons. And the love today of the supermax context, which gives people, I would say, too much privacy, the isolation. I think that associational privacy is an interesting concept that might be useful in this context, because I have a student actually wrote a paper about this. One of the reasons why solitary confinement and supermax is so cruel, especially to Black people, but I think to everybody, is that we rely heavily on our social networks for our sanity, right? And so if you are by yourself and cannot engage in forms of communication, conversation, banter, commiseration, etc., with other people, then you become increasingly less and less human, if not increasingly more and more like an enslaved person, which we just absolutely will not tolerate. So those are some of the ways in which I think about prisons and privacy. And as a philosopher, of course, I have read many times Jeremy Bentham's famous panopticon letters that advocate the use of a particular circular surveillance system in asylums and prisons and workhouses and so forth. And I include that material in my casebook, privacy casebook, because I want people to understand that there is a history to the design of prisons. And if you go back to that history and think about why prisons are designed the way they're designed, some of the reasons, some of the rationales for those designs no longer apply. I mean, so that we can give up on some of our habitual prison designs in the interest of a more humane kind of punishment.
Great, thank you. We have a couple minutes left, so I'm going to combine two questions into one, and then we'll end here. So some participants on this call understand you to argue that privacy can be a pathway or a means for arguing about other things like justice, including racial justice and so forth. And I think that's what you're getting with your anti-subordination principle. Is that an adequate way to respond or to counter the governing discourse in policymaking today that sees privacy often in economic terms? Like, this is something that we trade away, that we're willing to give up for benefits, or that privacy is incompatible with innovation, and a lot of these kind of dichotomies that policymakers, especially neoliberal and conservative policymakers, that set up and say, well, you get to choose, this is something that you decide on the market. Your reorientation of privacy to focus on anti-subordination, do you think that is the way to respond or to shoot down that discourse? Because this economic good way of thinking about privacy is not helping us. It's not helping marginalized populations, nor is it helping the rest of us and everyone else gain the benefit of privacy protections.
So even before the events of this year, and before I decided to focus on race in this way. I had already begun a philosophical project, which was attempting to change the way we think about privacy. Privacy is not, to me, a take it or leave it commodity or good like ice cream and fast cars, right? From that. It is, to me, something extremely fundamental, I call it foundational importance in my book, Unpopular Privacy. And that idea goes again back to this idea from the passage case, the idea that when you are subjected to privacy intrusions, you are to that extent enslaved. You're subordinated. You're treated as not free, and potentially as not equal, and unjustly. And so, I do think that this line of thinking is potentially helpful and responsive to this tendency to think about privacy. But we do have to fight the libertarian notion of privacy as a take it or leave it thing. We have to instead insist that privacy is grounded in fundamental rights of the sort that deserve to be human rights and deserve to be incorporated into our positive law. And that just as we don't allow people to sell themselves into slavery, we should not allow people to give away their privacy or to sell their privacy. Absolutely. There are going to be limits. Everybody's life needs to have substantial opportunities for privacy and private choice. It doesn't mean that we never give up privacy, but it means we do so in a way which preserves the opportunity for privacy and private choice. Finally, we can see this right now with the coronavirus. We're all giving up our freedoms, wearing a mask we don't want to, symptom checkers on our the apps on our phones, we don't want those, getting our temperature taken, being forced to take tests, and ultimately being forced to take vaccinations as condition of going back to work. All of that, it can be seen as intrusions upon private choice and bodily integrity, ... But most of us feel like those are justified, hopefully temporary, measured ways to respond to a crisis. Our whole life will be a life of privacy, even if for a moment in time we have a lot less than we'd like. But I just, so we got to face these arguments head on. We do have to, even as liberals, we can critique the liberal conception of privacy because liberals do accept the idea that, that freedom itself is a fundamental interest of all human beings.
I think that's a great place to end, and also a clarion call to bring back some of our law and political economy, legal realist or Marxist backgrounds to think about how we need to approach these. I want to thank everyone for participating, and a special thanks to Professor Allen for joining us. One of the bad things about being on Zoom is that you can't hear the applause of everyone joining, so silent golf clap.
Thanks a lot.
But I know everyone here appreciates it. It's an honor for me to participate. And thank you everyone for joining. I hope this was stimulating. I know it certainly was for me. So thank you so much, Anita.
Thank you. Take care. Bye-bye.